Recently my college group is filled with disqualification of Rahul Gandhi as MP and I don't have any idea about the same too. Why was Rahul Gandhi disqualified? What does the law say on disqualification of convicted representatives? And what happens now?
Congress leader Rahul Gandhi was on Friday disqualified as a Member of Parliament, MP, of the Lok Sabha following his conviction by a Gujarat court in a defamation case filed against him.
Why has Rahul Gandhi been convicted?
The case pertains to Gandhi's controversial speech delivered in Kolar during the 2019 political campaign, wherein he had linked Prime Minister Narendra Modi with fugitives like Nirav Modi and Lalit Modi. He had said, "Nirav Modi, Lalit Modi, Narendra Modi. How come all the thieves have Modi as a common surname?" Purnch Modi, a former BJP member of Legislative Assembly, MLA, took exception to the said speech, claiming that Gandhi humiliated and defamed all persons with the Modi surname. The court agreed with that and held that Rahul Gandhi had insulted all persons with the surname Modi. Judge Haydarash Varma said that since Gandhi is a Member of Parliament, MP, whatever he says will have a greater impact. Thus, he should have exercised restraint.
What sentence was imposed?
Gandhi was convicted under sections 499 and 500 of the Indian Penal Code, IPC, the maximum sentence for which is 2 years and/or fine. The court, however, granted him bail and suspended the sentence for 30 days to allow him to appeal before a higher court.
Why was Rahul Gandhi disqualified from the Lok Sabha?
A notification issued by the Lok Sabha Secretariat less than 24 hours after the Surat court ruling stated that Gandhi stands disqualified as an MP from the date of his conviction, in terms of the provisions of Article 102(1)(e) of the Constitution of India read with Section 8 of the Representation of the People Act, 1951. Article 102(1)(e) states that a person shall be disqualified for being chosen as, and for being, a member of either House of Parliament. If he is so disqualified by or under any law made by Parliament. The law made by Parliament in question is Section 8 of the Representation of the People Act, 1951, which disqualifies representatives on conviction. Section 8(3) of the Act states that when a person is convicted of any offence and sentenced to at least 2 years of imprisonment, she or he attracts disqualification. The period of disqualification under the Act is stipulated to be 6 years from the release of the convict from prison. However, subsection 4 states, notwithstanding anything, in subsection 1, subsection 2, or subsection 3, a disqualification under either subsection shall not, in the case of a person who on the date of the conviction is a Member of Parliament or the legislature of a state, take effect until 3 months have elapsed from that date, or, if within that period an appeal or application for revision is brought in respect of the conviction or the sentence, until that appeal or application is disposed of by the court. In effect, Gandhi ought to have been given 3 months from the date of conviction before his disqualification as an MP took effect. However, this provision is a nullity in light of a 2013 Supreme Court ruling.
Can the disqualification be set aside?
The only way Gandhi's disqualification from the Lok Sabha can be overturned is if a higher court stays the conviction by the Surat court. However, the appeal needs to be decided in favor of Gandhi and the higher court must stay the conviction and not merely stay the sentence. In its 2018 judgment in Lok Prahari v. Union of India, the court had held that upon a stay of a conviction under Section 389 of the Code of Criminal Procedure, CRPC, the disqualification under Section 8 will not operate. The authority vested in the appellate court to stay a conviction ensures that a conviction on untenable or frivolous grounds does not operate to cause serious prejudice, the three-judge bench of the then CJI Deepak Misra, Justices A.M. Khanwilkar and I. Chandrachud had held.
Is there a recent example where such a disqualification has been set aside?
In January this year, the Kerala High Court suspended the conviction and sentence of Lakshadweep MP Muhammad Faisal PP in a case alleging attempted murder of a political opponent. This effectively rendered the disqualification of the MP by the Lok Sabha Secretariat inoperative. Justice Bichu Kurian Thomas said in the order that such a step is required to avoid a costly re-election and also considering the fact that the candidate so elected would only have a term of 15 months. Thus, the High Court noted that this case was rare and involves an exceptional situation warranting suspension of conviction. This was further cemented when the Supreme Court bench of Justices K.M. Joseph and B.V. Nagratna refused to stay the High Court order after the Lakshadweep administration filed an appeal challenging it.